You got 5 minutes. Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Just write that question, the first question.
Oh, ladies and gentlemen, you're to disregard the answer to the first question, okay?
Your Honor, it already came into evidence.
Ladies and gentlemen, can I ask you to return to your headquarters for just a second, please? Sir, if you could step outside for me, please. The jury has left us. Mr. Steele, you've got to stop commentating or offering commentary in front of the jury. I've warned you about 4 times. If you do it one more time, I'm going to hold you in contempt. Contempt is punishable by a fine and/or jail of up to 20 days. I don't want to have to do that. But please do not comment in front of this jury anymore, okay? That's the only thing I'm going to tell you. Do we understand one another? I need an audible response, sir.
I said yes, sir.
Okay, all right. Just as long as we do that, okay? But, all right.
I would like the court to look into the appropriateness, Mr. Copeland, to my observations around your courtroom, outside your courtroom on breaks, is surrounded by several members of law enforcement with the district attorney's office and prosecutors, potentially other persons. I don't know why a sitting witness under oath is in a room with prosecutors during breaks, mornings, afternoons. It's totally inappropriate. There are people who are in your court's door. There's a double door where the court sits to its right that aligns with the witness chair, and I noticed people standing there in law enforcement while Mr. Copeland is testifying. He's making eye contact with them. I don't know if they're his brother. My point to you is this: what gives anybody the right to surround a witness, he's not in custody, and bring a witness? I'm sure Mr. Copeland didn't say to the prosecutors, I don't know this, Your Honor, so if you think I'm wrong, then just strike it from your memory. But I'm sure he didn't say, hey, you guys want to hang out in this room a little while? So I believe that he is being led on a tether by the prosecutors, and it is coercion. It is inappropriate. And why would anybody not be recording everything he said? And why do I have to get it in drips and drabs? So I am objecting to the tactics of the Fulton County District Attorney's Office and whomever else they may have employed with a citizen, regardless of what the court may think of him or the prosecutors think of him.
I don't have any thoughts, so please don't put that in. Please don't put that in in the ether. Okay, but that's what you just said, sir.
The ether is
okay.
Clear. The court wouldn't do it. I wouldn't do it either. So why is it happening? He's a
See, I have no interest other than I'm a referee.
Well, you're the referee who spoke with the witness without my presence. So
Mr. Steele, we're not gonna get into that right now.
Well,
okay?
my point is, how is he being treated here? And why don't I have all this? And why is this going on? What an unfair trial for Mr. Williams. Think about it. If you were accused, Your Honor, and the judge met with this witness, with the prosecutor, and you sat next to me and Mr. Adams, you would say to us, what kind of case is this? Now he's being surrounded with all this law enforcement. My point is,
Your Honor, we're going to object that this.
I'm not going to be interrupted.
Mr. Steele, hold on. No, but you're Mr. Steele. Mr. Steele.
Yes, sir. What?
Okay.
I want to finish. I'm making a record for the court to understand.
Well, Mr. Steele.
I've never been interrupted in a court except for this one. You allow.
Well, you know, but the challenge is in this point in time is that some of the things that you have said at certain points in time are not appropriate.
Not true.
Okay, well, that's the court's.
The court is wrong.
Well, you have, everybody has an opinion, and it can certainly be reviewed at the appropriate time.
I have a right
But
to make a record.
but finish up so you can go ahead and make your
I'm not
record.
interrupt anymore about prosecutor or anyone. This is a record. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so,
What
we don't know that. We don't know whether or not they're true.
going on? Every time Mr. Copeland comes in the courtroom or out of the courtroom, he's escorted by a DA's office investigator. You see that? This court is observant. You're not just sitting there in a cloud. You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland and he said these things. Why?
Okay.
Why do I have to bring up? You should be bringing it up. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial. So I am moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of hold on. You have accused her of misconduct as well. And remember what I told you about your professional response. Remember what I told you about your. And she's going to take me down as opposed to you. So when I start talking, stop talking, please. Okay? I'll let you complete your record.
I
Okay?
understand the one party talking. I got it.
All right. Okay. All right. So I told you, several times before, I told you and your colleagues, remember your professional responsibility. And let's not make this an ad hominem issue. I don't believe that either one of you are trying to do anything that would subvert your ability to practice law. So, but.
Ms. Love has intentionally lied to the court numerous occasions. You do nothing.
Hold on. Let him finish. See, this is Mr. Steele. This is exactly what I'm saying. You cannot. It is not a good idea to state that your brethren across the bar are lying. Okay, in any time or any way.
I don't like doing it.
Okay, but don't. So don't. But don't because you don't because you don't have any proof.
I have all the
If you have proof of it, then you have proof. There's a mechanism in law and under the rules for you to submit that question to the Office of General Counsel and for the investigation to occur. But please stop, both of you. I've told both of you earlier, stop making these ad hominem attacks toward one another. Okay?
Everyone gets attacked. You say nothing.
Well, okay, but I've said something. You're going back to stuff that's happened in the past. So while I'm trying to deal with things that are current, so I've told you all most recently, as of about a week or so ago, to stop all this. Remember, I told you the world's watching you. They are. So please don't from this point on, do not accuse each other of anything. If you want to go ahead and do it, there's a proper way to do it, but don't bring it up in front of me. Okay?
I'm just making a point that this has been going on and it's abusive. That is my point.
That's your assertion, sir, as a lawyer, okay? And maybe your frustration with everything. Like I told you, this trial's gone a long time. There's a lot of wear and tear, but everybody's got to rise above and be a professional advocate. That's what the system demands of you.
I'm not worn or torn. I am here to tell the court that from a objective, casual observer, could see what's going on here is inappropriate.
Okay. At the end of the day, I understand your concern that you have now shared with the court. Because I did cover this last week. We covered this already. So,
Your Honor, I don't understand how Mr. Williams is having a trial that's fair.
I'm sorry.
I don't understand. From my perspective, Mr. Williams is not having a fair trial. I cannot cross-examine Mr. Winfrey. Now, this witness is telling us what he means by having things not look like street items.
Shit.
Whatever.
I remember.
Okay.
Okay. So.
I don't understand how any of this is coming in. Amina Diab is not a witness that the state is calling at all. I don't have a burden, you keep telling me, which I know the law, but you keep telling me that, but it feels like I have a burden because I have to clean all this mess up. And the
If you choose to do so, sir. And that's your characterization of it. So
the indictment, quote unquote, redacted, is a farce. This thing has, I don't know if you looked at your copy, there's blanks here that identify Jeffrey Williams. I mean, you'd have to be a deceased person not to realize that the indictment is charging Jeffrey Williams in it. And the state just goes on like, this is no big deal. You know, I have a big deal. This entire case should have witnesses who are competent to be cross-examined, and they don't. I, again, object. This gentleman is testifying. He has no basis in saying what Jimmy Winfrey meant or didn't mean. The recording, because of your ruling, speaks for itself. He shouldn't be able to interpret it, just like I can't interpret it. And it was never even done. What the jurors won't know is that Amina Diab didn't give any paperwork at all.
Yeah,
in fact, what they don't know is that Jeffrey Williams, because the state won't probably play it, a recording with Jeffrey Williams where this detective asked Jeffrey Williams, does Jimmy Winfrey work for you as your road manager? And Mr. Williams laughs and said, are you ridiculous? I have real legitimate people. So all of this is the state of Georgia getting out a theory that is not based in fact and that should not come into this courtroom. This entire, since the state has been allowed to say, does this help the investigation? This case has gone south. Maybe it was south already, but it has gone so south, I can't do anything. Those are all my objections. I'm moving for a mistrial. I have no idea why this gentleman got to say Amina Diab works on the legitimate side of the business. We're presumed innocent. He has no right to say that. And then this indictment is all hearsay under the Brown case, State versus Brown, which the Honorable Court agreed with, yet the state's using the indictment as a weapon. They're saying it says it in the indictment. Mr. Winfrey played Alford. He's not testifying. You let it in as a statement against his penal interest. Well, that's only against him. He's not on trial. It can't be a co-conspirator statement because it is a statement that does not further any supposed conspiracy because it spills the beans. So for all of those reasons, I mean, we could just use one, but for all of those reasons, I named 3, 4, 5, or 6, I'm respectfully asking the court to strike all of his testimony that goes into anything anyone else said and the investigation, and let's wipe this slate clean, and please, I just want to go forward and have people to cross-examine.
this is the second time you've made the same argument, sir. I understand it, and it's your right to do so. All right. First order of business the court needs to take up this morning. I have two motions to recuse, one filed by defendant Jeffrey Williams that was filed yesterday.
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm
how.
not gonna, Mr. Steele, I can't argue with you about anything such as, I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver's gonna prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right,
Glanville,
sir.
you allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no construction. There's been no purposeful. I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
No,
ad hominem
I'm
attacks? Really,
speaking.
could we strike that?
Okay, hey, everybody,
Sit
calm
down.
down. Everybody,
This is me
both of you
false.
please be seated.
Judge, I'm not
Both
done.
of you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the
Okay, but
case.
Mr. Steele.
I asked you, please.
Mr. Steele.
Please, Judge.
Mr.
How would you feel if you were being treated like
Mr.
this?
Steele. Mr.
Well,
Steele.
I'd like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor, of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, though.
But there,
And Mr. Williams, you know, to me, this is an innocent man. You talk about, Miss Love said there's a man in the Fulton County Jail who shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object to the ad
it's
hominem
Mr.
attacks, and I ask for
All
restricted.
because she wants to
Again,
win the
from the
case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have, and now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it, and you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I
Miss Love can
object.
try to silence me. Will not be silenced.
But Mr. Steele, here's the thing, okay? I think that, Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir, please be seated.
Whatever you do is fine, but I care about Jeffrey Williams. It's the best here.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that at times tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that, there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial, and so not only for the purposes of this, but it sends not the message I think you want it to send. All right, so I'm going to leave you all to your wise discretion in order to do that, but I'll take up whatever I need to take up as I see fit. But I know that you all. This has been a long trial. It's very demanding, exacting, and grating on, and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see, and kind of look at, and just remember that you do represent of who you represent and what you're here for. In terms of the tape, or the phone calls from Fayette County. It's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's what, and Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence, and I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury. She's saying that particular type of file has other things with it. I don't think you were given those. And that's what she's trying to get. So I'm in no way blaming anybody in this particular circumstance. But if you want that particular file, and I think you all should have the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all we can take that up. And it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. And remember, y'all are going to see each other over and over and over again. And, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right? So I'm just going to recess and we'll see where Mr. Melnick is at that point in time. And then we'll, I can talk about Monday for certain. Okay? All right. Okay. I'm just going to recess in place. All right. Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand, and I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raise it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you.
You're
threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sum and substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well, then, other than
answer
if
that
you were
on the
if you were sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton. Or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got this information.
I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your
Becoming-
motion. I'm going to deny your motion.
I
for
understand that
mistrial.
you spoke with a
And
witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is
you-
appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another day.
exclude in the first place? I didn't know about this stuff.
That's for another day. So,
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it
Does the
supposedly.
state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
State
why
does.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because
what
unless
I
you're
got-
sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
I'll
entitled
let,
to the
you know, that's
But isn't that the issue?
that needs to be told. But,
But,
State, do
but
you have
right
anything
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right under
Just
the
stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
because
paragraph
you've
12.
already said that. You've already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love. Sir, that's not what happened. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only
Okay, well then you've made your. No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.